right, so Detective Susie, Savannah Rice, and the defendant will be allowed in the courtroom. All of the witnesses are sequestered. I'm leaving it up to the attorneys to make sure you do not have a witness in the courtroom, because I can't identify all of them, I don't know. So if there's a witness who's in the courtroom outside of these three, they're not going to be allowed to testify if they're in the court, okay?
Yes, sir. And Your Honor, we would also need, given that it's being televised, an order from the court instructing those who've been sequestered not to be watching this elsewhere.
Yeah, what we need to do to make sure there's, where the where the witnesses are going to be awaiting their testimony, don't allow any electronics or anything.
We could go over there and else.
Yeah, we'll have courthouse security monitor, make sure there's no electronics in there.
Okay, I'll tell you, we have a couple witnesses in the state anteroom right there, and I'll have our helpers, our assistants just advise witnesses not to watch the news or anything.
Well, no, I mean, I want to, because I've had this come up in past trials, no electronics, no phones, no computers, no TV sets, nothing in the witness waiting area, okay?
That's fine.
All right,
Thank you, Your Honor.
all right. Anything else from the defense?
Yes, sir, Your Honor. There was one motion that we think we failed to mention yesterday, if the court would hear it, just related to some physical evidence and picture evidence of guns, Your Honor. I think that'd be improper in this case. They don't have a murder weapon in this case, Your Honor. The defendant did own guns, but any effort to put those into evidence we think is improper. I think it's improper effort to try to characterize the witness in a manner that violates their constitutional rights to own guns.
All right, what's the state's position?
It's a shooting death, and the guns that we intend to introduce are the same caliber as the bullets that killed Mr. Rice. They were submitted to SLED for examination. They are certainly relevant. We did not bring in every gun that the defendant owns. And quite frankly, our information is that we don't have a murder weapon because she threw it in the intrafiscal waterway. So the two guns that we have, that we intend to introduce, are the same caliber as the bullets that were recovered from Mr. Rice's body.
But what does the ballistic show? Were they the guns that fired the bullets?
No.
Then what is the relevance?
To show that it's still part of the investigation because they saw guns that match the caliber. They're submitted to SLED to determine whether or not they're the murder weapon, and they are not.
Well, then, what if it was a bazooka? He owned a bazooka, but the bazooka wasn't used to kill the defendant because it's the same caliber. If it has been excluded as a murder weapon, then what is the relevancy of putting the picture into evidence if for no other reason than to tell the juror
Not relevant, quite frankly.
So you're saying that every person that owns that caliber of gun would be a suspect?
Not unless they have the same motive that this defendant did.
Okay. Now, if you've got a picture of a gun that your testing has shown is not the murder weapon,
We have the actual gun is because the SLED examiner needs to look at that and say, he cannot testify that it's excluded unless he sees the actual gun and says, yes, I recognize this firearm. Here's the SLED lab number. Here are my initials. Here's the SLED item number. I looked. This is not the murder weapon. I don't see how that's prejudicial if we're saying it's not the murder weapon.
well, if I have a gun, it's not prejudicial for you to put it in, but it's not relevant either.
You're not the defendant.
I know, and I understand that, but what I'm saying is, I don't see the relevancy of putting in a picture of a firearm that is not involved in the crime.
So it's not relevant that we were able to exclude 2 guns as a murder weapon.
Why do you want the jury, are you gonna put in every weapon that was excluded?
There were only 2 that were excluded because there were only 2 that were the same caliber. As I said, they did not seize every weapon that Ms. Jackson had. They only seized the weapons, and the only weapons that were submitted to SLED were ones that possibly could have been the murder weapon.
But
That is
ultimately were not.
right, but that's part of the investigation.
Well, you can say that it's
But
part
the
of
SLED
the,
analyst will not testify unless he sees the guns. They can't do it because they can't definitively say, this is the gun that I tested.
well, they can testify that they did not test any guns that proved to be the murder weapon without putting a photograph of the gun in.
It's the actual gun. I have a photograph of the person who recovered it, but we have the actual guns. The SLED analyst doesn't look at a photograph and say, no, that's not the weapon. They look at the actual weapon. They test fire those weapons, and then they...
But you have the actual gun that is not.
Yes.
Okay, I'm gonna grant the motion to exclude pictures of the guns. I don't see the relevancy. There has to be a relevance, and you have a firearm that is not part of the crime.
Well, Your Honor, you are substantially crippling the SLED witness's ability to testify.
That, why can't he testify, I tested the guns provided by police and none of them were the murder weapon?
Because that's not how, SLED has very exacting standards of how they testify. He needs to be able to say, yes, this is the weapon that I examined. And if you're excluding photos, that's fine, but as I have said, we have the actual weapons that he testified and compared against the bullets.
Well, the basic premise is that evidence must be relevant to the case. And I don't see where a firearm that was excluded and is not part of the murder weapon, it's not part of the crime, it's not in any way associated with the death of the victim, is relevant in this case, other than to show that the defendant owned firearms.
No, it's to show that the investigators conducted a thorough investigation.
Well, you can do that without putting the gun in, saying, yes, we recovered guns, yes, we found guns, we had them all tested, none of them were the murder weapon.
And that is somehow less prejudicial than showing a photo and the actual 2 guns that were tested and excluded.
Yeah.
So I can have an investigator say that they found 20 guns in her closet, they recovered 2, and those were not the murder weapons.
Exactly.
Okay, I was trying to limit
You
the,
were trying to get in a physical thing to show to the jury that said this defendant owns guns. This is the same caliber as the one that killed the victim, so therefore the defendant must have killed the victim.
no, that's actually not what I was doing, Your Honor. Part of a thorough presentation, especially with SLED witnesses, is that we present them with everything that they examined. I have done this in innumerable trials, and there are plenty of times when it is not the murder weapon. I did it in the Samantha Raven trial, where we had a gun that was recovered and it was not the murder weapon. It is part of the investigation. It's part of the res gestae of the investigation. And so essentially you are crippling the SLED analyst's ability to testify because he needs to see what he actually examined.
I think he can testify without saying that whatever Horry County law enforcement brought to SLED for testing was not the murder weapon.
Okay, but if I understand Your Honor's ruling correctly, I can have my witnesses, which I was not going to, but now I will, testify that there were X number of guns in the defendant's home. They seized 2. Well, they seized 3, but they submitted 2 to SLED.
Right.
And those were not the murder weapon. So the state is not precluded from saying how many guns she actually had.
I don't know that
One-
there's still a relevancy issue.
That's right.
I mean, what you're trying to do is paint the defendant's guilt based upon the fact that she owned guns.
I'm not, Your
And that the
Honor.
defendant was murdered
No, it's,
by shooting.
Your Honor.
I understand your argument. I made your number, let's move on. The photograph does not cut it.
Thank you, Your
All
Honor.
right.
And that's also the physical evidence of guns as well, Your Honor.
Do what?
The physical, that's all, your ruling also extends to the physical.
I don't see the relevancy of a firearm that's not involved in the crime being relevant to the case. If it was not the murder weapon, it was not fired, it was not used to kill the victim, and the defendant is on trial for murdering the victim, I don't see the relevancy of any firearm or any weapon that is not the murder weapon being used.
Thank you, Your Honor.
All right?
I have had a chance to look at Detective Marcus's, presentation or report. If we'd like, I can hold off and make this argument later, so we can get started. If you'd like to hear from me, we discussed it yesterday. They provided me a report
It's a
of
presentation.
his presentation for his Cellbrite presentation.
All right, we hear from you on that.
Okay, so Your Honor, this is, now that I've had a chance to review this, it's an attempt to summarize the testimony and essentially present a closing statement through a witness. They are going to offer him as a digital forensics expert, is my understanding, and I can challenge those qualifications at a later time. But even if you accept the principle that he is a digital forensics expert, they have included in here things such as surveillance still shots from a restaurant. That has nothing to do with cell hawk data. That has nothing to do with GPS location data. That is a picture of a witness and a co-defendants eating dinner. They've added into this license plate readers. Well, Detective Marcus isn't an expert on license plate readers. It is a summation of the entire case in a packaged form, stamped with the name expert on it, to be presented to the jury. And it's just
So what
not.
are you asking?
I'm asking you to suppress or prevent her from showing demonstrative evidence that is outside the area of his expertise and could confuse and mislead the jury.
All right, what's the state's position?
Well, Your Honor, I don't believe it's stamped with expert, but what Sergeant Marcus does is he uses other items of evidence, which will already be in evidence, to validate the fact that, say, cell hawk, based on the longitude and latitude contained in the defendant's cell phone records, they say she was at point A. In order to validate that, so I am not just willy-nilly saying defendant was in point A, here is an LPR tag reader saying she passed by this area. Therefore, that helps validate that she was here. There's a picture of the defendant in Abuelos on her phone. There's geolocation data that shows that her phone is in that location, so it's going to validate the data that was provided to the defense long ago. Because I guarantee you that if we just had someone coming up and saying, cell phone data, how's her there? Well, how do you know? This is a way to validate the very records that we have provided.
All right, anything in reply?
Yes, sir, Your Honor. Again, that's what makes it even extra dangerous. Because if it was just GPS, maybe I could understand that. But this is cell hawk data, which requires someone to testify who is an expert about how wide those ranges are. So on the one hand, they're saying that they're going to present evidence that shows a cone, the conical shape of where a person could be based on that cell phone data. And then they're going to show a picture to say, oh, look, they're together. And so that can mislead the jury to think every time there's a cell hawk ping, that means the two of them are in close proximity. But a wide range, Your Honor. So that makes it even more dangerous and more misleading to the jury.
All right, I'm going to deny the motion. I think the expert report is.
Your Honor, just real quick, this goes to my point, which is, this isn't something I've had before. This is something I got yesterday. I do believe it is a report.
I've made my ruling. Now, that's the first thing I need to lay the groundwork. When the court makes a ruling, that's the end of the arguments. Don't keep arguing your position.
Yes, sir, Your
All
Honor.
right? Anything else?
Yes, sir.
All right?
Oh, wait.
All right, let's bring the jury. Okay, hold for a second. Tell them to hold up.
Luke, stand up.
I think we got enough time. Let's go ahead and get them to bring them in here. Got a request for the jurors wanting to take notes, so I'm going to allow them to take notes, but I give them some instructions on note taking. this morning. That's great assistance to the court. I want to thank you for being on time, and I apologize for keeping you in the jury room for so long. Now, we are getting ready to start the trial of the case of the state of South Carolina versus Maegan Jackson. I've got some preliminary charges I need to give you before we get started on that case. I understand, Mr. Roberts, you have been selected as foreperson, is that correct?
Yes, sir.
All right, thank you for serving in that capacity. If you'd always occupy the seat where you now sit. The alternates, if you would always occupy the alternate seats unless you become a part of the 12-panel jury. As I told the rest of you, you're at liberty to sit in whatever seat you like, whether you alternate seats, use the same seat, or whatever makes you feel more comfortable. All right. As I also told you during jury qualifications and during voir dire, jurors, just like witnesses, are constantly taking notes. So I'll need all members of the jury to please stand and raise your right hand while the clerk administers the oath for you to serve as jurors on this case.
Do you solemnly swear or affirm you will well and truly try the issues joined in this case and a true verdict rendered according to the law and evidence, so help you God?
Yes.
Thank you. You may be seated.
All right. Is there any member of the jury that did not respond to the oath by saying I do or yes? If so, please stand. Thank you very much, ladies and gentlemen. Now, we're getting ready to start the trial of the case of the state of South Carolina versus Maegan Jackson. Now, I know from watching TV shows, movies, reading books, things for entertainment, trials are usually full of a lot of suspense, a lot of action. While that might be the case in this trial, it probably won't be. I think what you're going to find is that trials are often slow, repetitive processes, the exact opposite of what you might be accustomed to when you read about trials or watch trials for entertainment purposes. But I hope you do find the trial entertaining. I hope you find it educational, and I want to thank you from the outset for serving as jurors on this case. Now, the attorneys appearing before you are advocates for the parties they represent, but first and foremost, they are officers of the court. They're sworn to uphold the integrity and the fairness of our judicial system and to help you in a search for the truth. You should expect them to be professional, competent, and ethical in the representation of their clients' interests. What I now say to you is intended to serve as an introduction to the trial of this case. These remarks are not a charge on the law of this case. I'll instruct you on the law applicable to this case at the end of the trial before you retire to consider your verdict. This is merely an explanation of the procedure that we will follow in the trial of this case so that you can better understand what might be happening. Now, the defendant is charged by 2 indictments, one charging the defendant with murder and one charging the defendant with criminal conspiracy to commit murder. Now, I'll explain the elements of those crimes to you at a later time. What you need to know now, though, is that these indictments are simply the charges by which this case is brought into this court. They are not, in any sense, evidence of any of the allegations contained in them. The defendant has pled not guilty to these indictments, and therefore the state has the burden of proving each element of each indictment beyond a reasonable doubt. It will be your duty, ladies and gentlemen, to decide whether or not the state has met that burden. Your purpose as jurors is to find and determine the facts of this case. You're the sole judge of the facts of this case. If at any time I make a comment regarding the facts of this case, you must disregard my comments. You are to determine the facts of this case from the testimony that you hear and any other evidence that is introduced during the trial of this case. It is up to you to determine the inferences which you feel may properly be drawn from that evidence. It is especially important that you perform your duty of determining the facts diligently and conscientiously, because ordinarily there is no way to correct an erroneous determination of the facts by a jury. On the other hand, and with equal emphasis, the same law that makes you the judge of the facts in this case makes me the judge of the law. The law is given to you by the court is the only law that you may consider. You must accept and follow the law as I give it to you, even though you may disagree with it. Just as I cannot tell you what the facts of this case are, You cannot disagree with me about the law to be applied in this case. Your job is to take the law as I give it to you and apply it to the facts as you find those facts to be from the testimony of witnesses and any other evidence that is introduced during this trial. After doing that, you will then render your verdict, a true and just verdict under the solemn oath that you just took as jurors. Now, until I advise you to begin your deliberations, you must not discuss this case with anyone, including your fellow jurors. Don't discuss it with any friends, family members, or anyone involved in the case. After the case is submitted to you, you can then discuss it, but only in the jury room with your fellow jurors. The attorneys and parties in this case have been advised that they're not to talk to you at all, so they're not being rude. They're just following the instructions of the court. During the trial, you're not to read or listen to or watch any news reports about the case. This includes anything that may be in the newspaper or on the internet, the radio, or television. You must not consider anything you may have read or heard about the case outside of the courtroom, whether that be before or during the trial of this case. It is important that you keep an open mind and not decide any issue in this case until all of the evidence has been presented to you. The parties have made their closing arguments, and I've instructed you on the law to be applied in this case. It is your solemn responsibility to determine the guilt or innocence of the defendant, and your verdict must be based solely on the evidence as it is presented to you in this trial and on the law, as I instruct you during and at the close of the trial. Now, in just a moment, the solicitor will make what is called an opening statement, in which the solicitor will explain to you the issues in this case, or at least what the solicitor thinks the issues in this case are. The attorney for the defendant may also make an opening statement, although he is not required to do so. What the attorneys tell you during their opening statements is not evidence in this case. It is only their contention as to what the issues in this case are. The evidence in this case will be presented to you by testimony of sworn witnesses from the witness stand and any other exhibits that may be introduced into evidence. Now, in determining what the true facts are in this case, you must decide whether or not the testimony of a witness is believable. It is my responsibility to rule as a matter of law as to whether certain testimony is admissible at all or not. But once testimony is admitted into evidence, whether or not you believe it is solely for you to determine. In deciding whether to believe a witness, you have the right to consider the interest of any witness, the bias of any witness, the prejudice of any witness, the opportunity for the witness to have seen the matters and things about which the witness may testify, and the way the witness acts on the witness stand. You have the right to consider anything that is in the record that will help you evaluate the testimony of the witnesses. That means that it is your duty to pay close attention to these witnesses, to observe the witnesses, to listen to the witnesses, and pay close attention to the attorneys and to the court. Don't let your thoughts wander, but give strict attention to the testimony in this case, so that at the end of all of the testimony, after the arguments of counsel and a charge on the law by the court, you will then be in a position to determine what the true facts are and apply the law to those facts, and thus render a true and just verdict. Now, I understand that some of you have asked to take notes during the trial of this case. I will allow you to take notes. However, I must give you some instructions on note-taking. First of all, your notes are personal to you and cannot be shared with anyone. So the clerk of court is going to provide you with a pad and either a pencil or a pen or writing instrument. The first thing you need to do is to write your name on the first sheet of that pad. And make sure you use your pad every time and you don't share it with anyone. When you leave the courtroom, take a break or whatever, you'll need to leave your pads in the jury box. When you return to the courtroom, make sure you have your pad and no one else's pad. Next, don't try to write down everything that is stated by a witness. You're going to miss some testimony. The purpose of note-taking is to jot down a note to refresh your memory as to a matter that you think is important. If you try to write everything a witness says down, number one, you're not going to observe the witness. And number two, you're not going to be able to keep up with the entire testimony. But if a witness testifies to something or an exhibit is introduced into evidence and you want to make sure you remember that at a later time, just jot a quick note to refresh your memory. And then finally, note-taking is not required. Some people are better note takers than others. Some people can recall testimony and evidence without taking notes. So do not feel that you are required to take notes. You're not. It's up to you. It's a personal decision for you to make. All right, I'm going to go ahead and have the clerk of court hand out the pads, the writing utensils, write your name on the first page, and as I said, if you choose to take notes, just use it to refresh your memory. All right, ladies and gentlemen, we're going to begin the trial of this case with the opening statements, and as I told you in the opening charges, these statements are not evidence in this case. It is simply the attorney's contentions as to what they think the issues in this case are. Ms. Walter, Ms. Waller, who wishes to make a statement, please.
May it please the court, Your Honor.
Yes, ma'am.
Good morning. This week, you're going to hear facts and evidence in this case. And those facts and evidence are going to tell a story. And it's going to be a familiar story because it's a tale as old as time. It's the story of an affair, a pregnancy, and a murder. And the victim of that murder is Gregory Rice, the defendant's, the father of 4 of her children. And when you look at the facts and evidence and events that you're going to hear about this week, there's one person who connects all of those things. There's one person at the center of everything you're going to hear. And that person is Maegan Jackson. She's sitting right over there. Now, when you look at Maegan Jackson, you may think, she looks meek, mild. She's a small woman. But looks can be deceiving. And this defendant is certainly deceiving. She deceived Greg Rice. She deceived our co-defendant, Christopher Dontell. She deceived Christopher Dontell's wife, Erica Dontell. And she deceived law enforcement. So as you're watching this, make no mistake. The defendant may look like a victim or portray herself that way. She may look meek and mild, but she is a master manipulator. And that's what she did in this case. And not only is she a master manipulator, she was literally in the business of death. Her job back in 2020 when this occurred was as a body transport person, a body mover. So what she would do, she worked for a company that whenever someone died of natural causes, or if it was a homicide or even a gruesome accident, she would respond in her van and she would pick up the body and she would take it wherever it needed to go. So that's what she did. And in the course of that job and that employment, she met a man named Christopher Dontell. Christopher Dontell was also in the business of death. Before she got the job as a body transport business person, that's what he did. And he trained her. And then he became a deputy coroner, and it was his job, much like Maegan, to respond to these scenes of death and to fill out paperwork and to perform the duties of the coroner. In the course of that employment, Maegan Jackson and Christopher Dontell saw one another very often, and they became close. Now, Christopher Dontell at the time he had a pretty good life, a pretty normal, I would say, everyday life. He worked as a deputy coroner. He was married to a school teacher. community. And at the same time, Maegan Jackson had been in a relationship with Gregory Rice, the victim in this case. They shared 4 kids. About approximately a year before this murder occurred, she and Gregory Rice broke up. They were no longer together, but they were kind of always connected because they shared these 4 kids. You know, if you share kids, you're gonna always have to talk to someone. They would speak about the kids, they would text and call, and that's really what their communications were about. So after Maegan broke up with Greg, she pretty quickly moved on to Christopher Dontell. She set her sights on him, and she basically infiltrated his life. She literally bought a house in the same neighborhood right down the street from him. She befriended his wife. She befriended his kids. She started buying the family expensive gifts with an inheritance she had gotten and made promises of more. She spent her days hanging out with his wife and Christopher Dontell. She became, in a large part, a third party in their marriage. And because Christopher Dontell and Maegan Jackson were kind of dealing in death, they were doing this job where they were transporting bodies and responding to these scenes, they had a reason to be out at all hours of the day or night without anyone raising any suspicions with anyone. They could be together, they could be out all night, they could spend the night, he could spend the night at her house, and no one thought anything. She actually started an affair with Dontell and conducted that affair right under his wife's nose. She was hiding in plain sight, and she was deceiving everyone. So around, I'll say September 2020, a couple of things happened that kind of changed things. The first thing that happened is Maegan Jackson got pregnant with Christopher Dontell's child. At the same time, someone anonymously began exposing the affair between Maegan Jackson and Christopher Dontell to Erica Dontell, his wife, through texts and emails that kind of had pictures and statements about what had been going on. That was done anonymously, but Maegan Jackson represented to Dontell that Greg Rice was responsible for those things. Now, the judge said that you're the judge of the facts, and I'm going to ask you, as you're watching the facts and evidence that's presented in this courtroom, ask yourself, who had the biggest motive to blow up Christopher Dontell's marriage? Ask yourself that question. So that was going on, and then on October 2nd, 2020, Gregory Rice disappeared. A Friday night, he just disappeared. And Maegan Jackson began acting very quickly to divert suspicion away from herself. That weekend, she had an officer do a welfare check on Gregory Rice. She showed up at his house when normally she would make him come pick up the kids. That Monday morning, she showed up at the police department and filed a missing persons report. And in the course of filing that report, she tried to portray Greg as some degenerate drug user, which was the furthest thing from the truth. He basically went to work, took care of his kids, and stayed home. He was a homebody. So she was trying to divert suspicion. But police began looking first at people closest to him. So they look at Maegan Jackson. They just see quickly that she's having an affair with Christopher Dontell. The other thing that police start doing when they're looking for someone is they start looking at cell phone records. I'm sure, although I know you're not allowed to have them now, that almost everyone here has a cell phone, and you pretty much take it with you everywhere you go. I know I do. And when your cell phone, when you make a call, or you get a text, or sometimes when your phone's just running an app in the background or doing something, it connects to the cellular network and it hits these towers that are located around the county. There's one pretty close to the courthouse you may have seen. And based on those kind of cell phone records, police can identify the approximate location of people, where they are. They can kind of track movements that way. So police began looking at Gregory Rice's cell phone records. And one of the most striking things they noticed is the last person that he spoke to, the night he disappeared, October 2nd, 2020, was Maegan Jackson. Police also start looking to see where Greg was. So once they realize that Maegan Jackson's having this affair that she's the last person to speak to Greg Rice on the phone, or it looks like that's the last phone call he can. Suspicion falls on her and Christopher Dontell pretty quickly. The last phone call he can. Suspicion falls on her and Christopher Dontell pretty quickly. But nobody knows where Greg Rice is. So they haven't found him. Now, police know the longer Greg is missing, the less likely they are to find him alive. So as time passes, police began to suspect strongly that Greg Rice is dead. And lo and behold, about a month after he goes missing, Donna Sue Souls was setting catfish lines in the Little PD River. For those of you who don't know, that's the geographical border between Horry and Marion County. They were setting catfish lines in the middle of the night. They happened upon the body of Greg Rice. Greg had been shot. He had been wrapped in a tarp that was zip tied. Someone had taken ratchet straps and wrapped around it and weighted it down with cinder blocks to try to, and dumped him in the river. So that's a big break in the case for police. It also gives them a new lead to follow. That lead is they start looking at the tarp and the cinder blocks and all these items that Greg's wrapped in, and they start going to stores around Horry County to see if any store sells those items in particular, because those items have tags on them. So they end up going to Lowe's Home Improvement, which is a national chain, I'm sure you all know, and they speak to the security officer, and he starts looking at receipts. And he finds a receipt from October 3rd, the day after the murder, where a person bought all of those items together, and I think a Pepsi Zero. So he goes and he says, that's a rather suspicious shopping list. It's basically a murder dump kit. So he goes and looks at surveillance footage, and he finds Christopher Dontell pushing a shopping cart through the Lowe's checkout line with a cart with a tarp, zip ties, cinder blocks, and ratchet straps. And that leads police. They start looking for surveillance video. They know the body was dumped in the Little PD River. So they start looking for routes you would take to get there from kind of this area, the beach area where Christopher Dontell lived. And they find surveillance footage from a convenience store, Little PD Exchange, showing Christopher Dontell going back and forth to the dump site in his county vehicle. At the same time, of course, suspicion has already fallen on Christopher Dontell and Maegan Jackson, but at that time, police start looking a little closer. And they start looking at cell phone records, any surveillance they can get. They look at license plate readers. And for those of you who don't know, license plate readers are cameras. A lot of municipalities have them, and the Myrtle Beach has some out on the highways that the cameras capture the license plate of your car as you pass by. So you can tell where cars are on the highway sometimes by looking at these license plate readers. So police start looking at cell phone records, surveillance, and license plate reader to track the movements of Maegan Jackson, Christopher Dontell, and Gregory Rice. And what do they discover? Well, the most striking and obvious thing police discover is that Maegan Jackson and Christopher Dontell were together the entire night of October 2nd, the night that Greg went missing. They left, they met up about 6:30 in the evening at the Lewis Ocean Bay Heritage Preserve. That's just a wildlife management area where you can go, you can see endangered plant species or walk around and look at nature. But what they were there for, police find out later, was target practice. They were actually shooting guns. Maegan liked to shoot, so that's what they were there doing that day that Greg was murdered. They left there, they went to Abuelo's, which is a restaurant, Coastal Grand Mall, you may have seen it. They're on surveillance camera there eating for about an hour. They leave around 8, and then they come back. Christopher Dontell comes back about an hour later, about 9 o'clock, to use the bathroom. He tells police that in that hour they were driving around conducting their affair, that he was receiving oral sex from Maegan, that that's what they did when they were together. They eventually end up at Myrtle Beach Funeral Home. Now, Myrtle Beach Funeral Home is a funeral home. It's on the bypass over near Market Common. You probably know where that is. It's basically a crematorium. Maegan Jackson and Christopher Dontell had access to that funeral home because of their jobs. The county sometimes would store bodies in the coolers there if there were just not enough room at the coroner's office. So they were there, and their cell phone records put them there. Around 9:45, Maegan Jackson calls Greg Rice. And these are approximate times. Around 10 o'clock, she calls him a second time. At the same time, her body transport van, the one that she uses for work when she's doing her job as a body mover, is seen entering the homeowners associations, entering the gate of Arrowhead community where Greg lived. It captured on the homeowners association's license plate reader. She goes in there, or her van goes in there. It stays 6 or 7 minutes and then out. At the same time, from 5 o'clock to 10 o'clock that night, Greg Rice's phone is hitting off the tower near his apartment right there at Arrowhead at Flint Lake Apartments. So it doesn't look like he's moving. It looks like he's home. But around 10, the same time Maegan Jackson's van shows up in his neighborhood, his phone starts moving. And what his phone does is it travels to the Myrtle Beach Funeral Home. At the same time it's traveling, Maegan Jackson's van is traveling toward the Myrtle Beach Funeral Home, hitting license plate readers along the major highways in Myrtle Beach. So Greg's phone and Maegan's van go back to Myrtle Beach Funeral Home. Now Greg's phone stays there a little while and makes some data connections. So I told you before, whenever you use your phone, sometimes you're making calls or texts, and that's a user-initiated action that causes your phone to connect. But sometimes your phone connects without you doing anything. It can have something running in the background or some app that uses cellular data, and it'll connect without the user actually doing anything. So just because Greg's phone is connecting does not mean that he's alive. It just means that his phone is there. So eventually, Christopher Dontell and Maegan Jackson, you can see from phone records and LPR, start traveling towards the Lowe's Food on International Drive. That's an important location for them. That's where they would go to leave cars so that they could conduct their affair, so that there was just a place to leave the car, essentially. It's kind of close to the neighborhood. It's right by the Lewis Ocean Bay Heritage Preserve, where they were going for target practice. And around 11 o'clock at night, a computer store in that shopping center captures Maegan Jackson and Christopher Dontell on camera. Christopher Dontell has a bag. Maegan Jackson's there. Importantly, at the same time, Greg Rice's phone makes a data connection to a tower that would put him in the same vicinity, around 11 o'clock, a little after 11 o'clock that night. That's the last time Greg's phone ever made any connection with the tower. After that, it's just gone. So that's the last time Greg Rice's phone makes a connection. After that, Maegan Jackson, we learned later that Greg Rice was in the cooler at the Myrtle Beach Funeral Home, his body. After that, Maegan Jackson and Christopher Dontell go back to the Myrtle Beach Funeral Home to get they were getting belongings so that she could put some of those belongings to set up this welfare check that she did the next day to make it look like he had wandered off and OD'd. So they went back to get that. But something else happened that's a bit unusual. When they got there, around 12:45 that night, there was a trade embalmer there. And as I said, everyone in this case is kind of in the business of death. The trade embalmer, because Myrtle Beach Funeral Home doesn't have a full-time embalmer, they mostly cremate bodies. The trade embalmer would come on a contract basis and embalm bodies, and he did that kind of whenever it's convenient for him. You'll hear from him. So he was there at 12:45 a.m. that night. He was there in the middle of the night embalming a body. So when Christopher Dontell and Maegan Jackson showed up, he saw them there. And he'll tell you that. He saw Christopher Dontell there. And they left. They stayed together, you'll see on tape, they're kind of going back and forth. And then finally, they spend the night together, and then around 8:15 the next morning, they go back to Lowe's Food, and they get in their cars and go their separate ways. So back in December of this year, that's kind of what law enforcement knew about this case. And much like we did here today, Ms. Walter and I, the state of South Carolina, we called Christopher Dontell's case to trial. Just like we did today. We picked a jury, the same thing. We went through everything. And then as I was sitting in my chair, getting ready to stand up, Christopher Dontell shocked everyone by standing up himself and voluntarily pleading guilty to accessory after the fact of murder with no agreement with the state. That was also allowed law enforcement to fill in some blanks. Christopher Dontell, after he did that, agreed to speak to law enforcement to kind of fill in a lot of missing pieces of this puzzle. You're going to hear from Christopher Dontell. He's going to testify. I have no doubt that Maegan Jackson's attorneys will make a big deal out of the fact that Christopher Dontell has a motive to minimize his conduct and point the finger at Maegan Jackson. The judge has already told you. You, the jury, can decide what to believe, whether you believe some of what he says or all of it. He's going to tell you that that night, when he and Maegan Jackson were at the Myrtle Beach funeral home, she called Greg Rice because she wanted to go confront him. And that Christopher Dontell and Maegan Jackson took that body transport van in the Arrowhead when it hit that license plate reader. And they went in there, and Maegan Jackson called Greg, and when he came walking up to the car, she got out and shot him and killed him. And the two of them hustled out of that van and put him on their body transport stretcher, and they threw him in the back and went back to Myrtle Beach Funeral Home, where they put him in the cooler while they decided what to do. All of that testimony matches what law enforcement already knew. There's nothing that he's saying to us that is not borne out by those cell phone records, surveillance records, and LPR records. You'll see then, too, the next day is when he goes and buys this body dump kit and takes the body, dumps Greg Rice in the Little Petey River. So, you decide what to believe in this case. You decide who you think is responsible for the murder of Gregory Rice. Gregory Rice, and you're going to hear from Christopher Dontell, you're going to see Maegan Jackson sitting over there. The only thing Christopher Dontell and Gregory Rice have in common is Maegan Jackson, who's sitting right over there. That's the only thing. The judge is going to instruct you on the law at the end of this case. He's going to tell you about conspiracy. That's just what it sounds like. It's two people getting together to commit a crime. He's going to give you the definition of murder. In South Carolina, we don't have degrees of murder. We have one definition, and that definition is it's the killing, intentional killing of another person with malice aforethought. None of you guys need that definition to know that shooting someone, wrapping them up in a tarp, and weighing them down with cinder blocks and throwing them in the river is murder. But what you do need to know about South Carolina is South Carolina has something called the hand of one is the hand of all. I'm going to read you what that means. This is the legal definition. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act of all, or as it's sometimes said, the hand of one is the hand of all. Two people can be guilty of killing another person when only one of the two had a gun, there was only one bullet, and only one of the two fired the shot that caused the death. So what I'm asking you to do is if, at the end of this case, which I think it's pretty clear and obvious, who's responsible for the death and for the murder of Gregory Rice. And at the end of this case, if you believe that Christopher Dontell and Maegan Jackson are responsible for the murder of Gregory Rice, then there's only one verdict, and that's guilty.
All right, does the defense wish to make an opening statement?
Yes, sir, Your Honor.
All right.
May it please the court?
Yes, sir.
I'll be honest with you, I thought she was going to say Dontell at the end there, because that's what it sounded like, right? That at the end of all that Dontell was the one, the hand. Ladies and gentlemen, my name's Case Britton, and I don't want to talk at you guys. I really do my best not to talk at you guys. I'm here with my father, Tommy Britton. I'm here with my younger brother. He hates it when I say that, Preston Britton. I'll be taking a little personal moment here. This is the joy of my life. Probably the last time this will happen. I get to try a case with my father and my brother, but the actual brains are back at the office. I have a younger sister, and we have a new attorney too, Lauren Benton, and also a good staff of paralegals and assistants, which we couldn't be here without. That's the Britton Law Firm plug. So I want to talk about our roles here today. I'm a little different than most people, most lawyers. I like to talk with you guys, and I know y'all can't really talk back with me, but if I just don't want to seem like I'm talking at you, right? It's very tough for me to do because I'm here and y'all don't get to say anything back. But I just want to kind of talk about our roles here today. Our role, honestly, as a defense counsel, if I wanted to, I'd go sit down over there. I'd go sit down, I'd go talk to Mr. Britton. Mr. Britton would say, look, we're not going to say anything else. We don't have to say anything. We don't have that burden. We don't have to say a word. We could let the state put up a witness after witness after witness, introduce evidence, introduce evidence, introduce evidence, and we could just sit there. Not question them, not cross-examine, just let the evidence speak for itself. The evidence, and we'll talk about evidence and the types of evidence here in just a second. That's what we could do, but we'll probably engage with the witnesses that we put up, and we might put up some cases and some witnesses too. Now the state, let's go back to the state in a second. You heard the judge, and I have to be very careful when I talk about the judge because he is the rule. He's the man, he's in charge here. Solicitor and I, we may get some little arguments about something, whether it's admissible. I may not like her tone, although I very much doubt that. She may not like that tone. I probably can get that way. Sorry. I apologize if I come off gruff at sometimes or condescending. I don't mean that. But the judge is the one that tells y'all or us if we are right or wrong. Sustained, whoever made that objection, it's allowed. Overruled, can't do that. He's that guy. And then he, of course, like he said, he instructs you on the law. And he'll do that at a later date. Now, the heaviest lift in this whole entire courtroom, maybe besides y'all, the state. You've all heard these glorious things before. The burden of proof. It's heavy on the state. Innocent until proven guilty, right? Innocent until proven guilty. The state has that burden to prove beyond a reasonable doubt. And another fun little term there, reasonable doubt, we'll get back to that as well, that my client, who is shrouded in innocence, was presumed innocent all the way until y'all say she's guilty, until the state proves that beyond a reasonable doubt. That's the burden they have through all their evidence that they have. Now let's talk about the evidence they have. You have usually two types of evidence. You got direct evidence, and you've got circumstantial evidence. Direct evidence, though, is like DNA, blood, crime scene photos. That's funny, too, crime scene photos. So I'm not going to say there's not a lot of evidence. I'm not going to say there's zero evidence, zero direct evidence. But in a murder case, I'd like to see a lot more. I'd like to see a murder weapon. Don't have it. I'd like eyewitness testimony. Don't have any eyewitness testimony. I'd like video of the crime. I don't have video of the crime. I like audio of the crime. I don't have audio of the crime. I don't have any of that. I don't have any of that direct evidence. The stuff that a murder case should have. You have the weapon. Well, but let's talk about circumstantial evidence, because this case is loaded with it. Now, circumstantial evidence, I like circumstantial evidence. It gets a bad rap in like TV shows, and you heard the judge talk about that in movies. You know, it wasn't me, it was the one-armed man, you know, that kind of stuff. Those things, it's circumstantial. I love it because it requires y'all to infer. It requires y'all to question. Does it prove what it says it proves? A really good example, and I have to give my brother credit for this. You walk outside, the ground's wet. You remember last night, forecaster didn't say it was going to rain. Ed didn't say it was going to rain. So you think, well, maybe it rained. Also, possibly though, did your sprinkler system turn on? So what in the world could help you figure that out? Well, you kind of look over at your neighbor's yard. Well, his ground's wet too. What does that prove? Nothing, but except both your grounds are wet, because his sprinkler system could somehow run at the same time as yours. All right, so maybe you look to your neighbor to the left. Holy cow, his lawn is wet too. Now, if I'm the person that walked out and looked right and left, I'm starting to think, okay, It rained last night. I must have missed something. Quick shower. Hey, you live in Myrtle Beach, international waterway, rains in Conway, doesn't rain in Myrtle Beach. That happens, right? That's plausible. It's possible, right? Then you look across the street, and it's like the Sahara Desert. Your neighbor's got not a drop of land over there. You look to the left of his house, dry as land over there, and you look to the right of his house, sprinkler system still going on, and there's a flood going on. What do we know? We're pretty sure it didn't rain. And we're pretty positive that Earl on the end on the right there has got a flood. He forgot to turn the sprinkler system off, right? So the circumstance is different because the way you view it. You have to add it. You have to link those chains. You have to see that the fact that your neighbor's yard is wet, that makes it a stronger connection that something happened that made the ground wet. It doesn't necessarily prove that it was rain or prove that it was sprinklers. So you look to your neighbor's yard. It does the same thing. It's wet, but it doesn't necessarily prove it. It does make the causation link stronger. But then you look across the street and you see that it's not wet. It's dry. So what do you know? You know that no matter how strong this link, it doesn't matter. It doesn't prove that it came from the sprinklers. But it doesn't prove that it came from the rain. You need that other inference. You need to look at all the surroundings. Everything. That's what circumstantial evidence is. Now, in this case, we got a ton of it. A ton of it. Yes, you heard Madam Solicitor talking about the phones being together. Every single thing you heard Madam Solicitor say, guess who else was in there? Dontell. Then she goes at the end there, one of my favorite parts, the hand of one is the hand of all. So are they trying to tell you that you can convict Dontell? Just go ahead and convict Maegan Jackson too? Is that what they're trying to tell you? That if you can infer from all the evidence that Dontell is the one at the beginning of this, the end of this, the middle of this, and the one that has the most to lose, the one that has the motive? Deputy Coroner, wife and kids? Maegan Jackson had written Gregory Rice off. She's done. 15 years. Gone. See ya. Bye. She's already done something. She didn't need to do anything with him anymore. But a deputy coroner? Don't touch me, man. I'm a deputy coroner. He's got something to lose. That's motive. Again, circumstances. I want you're going to hear all kinds of evidence. We're going to try to cross-examine the best we can. Take each piece of evidence. Look at it. Look at the circumstances. Seriously. Most defense, when you've got a criminal defense attorney up here telling you to look at all the evidence, how many times do you hear that? How many times do you hear a criminal defense attorney say, look at this. Look at it. Look. Yeah, I know some bad things are going on here, but look. Really look at it. And if you can do all that, not worry about it. Because society's a little off. I feel like we want the worst sometimes. Flip on the news. War, gun, who got shot today? It's a bad time out there right now. Now I'm a little different. I really am. I look for the best in people. It's probably because I guess it's why I do what I do. I'm always searching. And it's not about me, but I'm always searching for the best in people. Every single person. Every single one. You. Everyone in here too. Love them. Don't know them. We have a chance in this courtroom, these halls of justice, to show that the presumption of innocence is paramount. All right? That innocent until proven guilty, means something. Means something. It means that you don't convict somebody of a murder without a murder weapon. You don't convict somebody of a murder without any video of a crime or a shooting, any audio of a crime, of the crime they're accused of, or shooting, or any 911 calls from an apartment complex of that evening with 5 shots. No 911 calls. 0? We don't do that here. We don't convict on circumstances that don't add up. It's like baking a cake or making some soup or whatever, missing the salt. You have to have everything. You have to have everything. And I guarantee you, well, hold on a second. One of my big things I was told many times before I came here, do not overpromise because you got to be afraid to underdeliver. Always got these little cliches. That's what I can't stand with this stuff. I just want to talk to y'all about it. I'm not trying to overpromise anything and underdeliver anything. I'm just trying to talk. We don't convict people on these kinds of charges, of these charges, of these serious charges, with no murder weapon, no video of the crime, no audio. Just don't do it. Presumption of innocence means something to people. We just can't do it. And I guarantee you, I hope that we can take ourselves out of this negative world, look at this evidence that's going to be presented, direct as much or as little as there is, circumstantial as much as little as there is. Remember that she's innocent until proven guilty. And look at everything. Everything. And say presumption of innocence means something. It does. And we will come back with not guilty. Thank you.
All right, ladies and gentlemen, before we begin the evidentiary portion, I think we're going to go ahead and take about a 10, 15-minute break, give you an opportunity to stretch your legs, use the restroom, whatever the case may be. Do not discuss the case, even among yourselves. Leave your notepads in the jury box. We'll take about a 10 or 15-minute break, and we'll come back and get started. Thank you very much. Anything from the state before we take short recess?
Nothing from the state, Your Honor.
Anything from the defense?
Nothing from the defense, Your Honor.
All right, we'll take about a 15-minute break.